Good morning, everyone. It's really good to see so many people here. If I were a Freudian psychotherapist, I think I might say something about Enid's last remark, given that Paul Marsh is a well-known ex-president of the Law Society, and I'm not. But I won't. So welcome here this morning. It's a real honor to be here, and it's really nice to see so many people filling the room. I am Paul Phillip. I am the Chief Executive of the SRA. I've been in the job now for just coming up for 3 years. Feels quite a short time from me. It might feel a bit longer from your perspective. This is the third compliance conference that I've had the privilege to attend. What's really encouraging, I think, is that 2 years ago, at my first conference, there were about 400 people at the event. And then last year, there were about 600 people at the event. And this morning, I'm really pleased to say that we have something like just under 1,200 people registered for this event. So actually, hence the slightly larger room. And actually, I think it's really positive. From our perspective, I think it means that at least you think it's worthwhile hearing what we have to say, even if you don't like it. So thank you for coming. I do very much appreciate that. I just wanted to take 10 minutes by way of introduction, really, to talk about some of the highlights of the last year and perhaps just to touch on where we're going next year. What have we been doing since last year and what has been occupying our time? Well, to begin with, I think it's probably worth mentioning that we're here really very much as the regulator of solicitors and solicitors firms. There are something like 170,000 solicitors on the roll. And about 136,000 of those have practicing certificates. There's something like 10,500 law firms, which includes something in the order of just over 400 alternative business structures. Clearly, we're a public interest regulator, and as you know, there are others that represent the profession, and of course, there's a tension there, a natural tension there, an elephant in the room, as you were, and it's come to the fore over the last year very much in terms of the issue about independence of the SRA as a regulator. The Legal Services Act tells us that in addition to promoting the public interest and promoting consumers' interest, we must promote competition in the legal marketplace. We must improve access to justice, encourage an independent and diverse legal profession, and then lastly, increase the understanding of legal rights. And it reminds us very much that our responsibility is to promote high professional standards and to uphold the rule of law. The LSB, the Legal Services Board, is the supra-regulator in the sector, and it has recently put out a paper suggesting that the Legal Services Act objectives should be boiled down to just one objective, and that objective should be to promote the public interest. And whilst in many ways I kind of agree with that, I think it's really important that we spell out exactly what the public interest is. For instance, it has to be in the public interest there is access to high-quality legal services provided by well-qualified, competent, diverse people in diverse businesses. It has to be in the public interest that there is a choice of affordable services, that there is the right level of consumer protection built in, that there is a thriving, competitive legal services market, and of course, we've already mentioned the administration of justice and the importance of the rule of law. So in a nutshell, really, those are our priorities. Nothing more, and in all honesty, nothing less. Perhaps the real debate is how we go about advancing those priorities. So I think it's important to recognise that what is good for the profession and what is good for the public sometimes conflate. Trust is an obvious example here. So it's very much in the interest of the profession that the public can trust solicitors. Hopefully you would agree with that. And it's very important that the public do trust solicitors. But it's also in the interests of society and the interests of the public that solicitors are able to be trusted. It's all about trust from my perspective. So those are our aims, and essentially that is the type of purpose. But there's lots of change around. There's lots of change around in the legal sector. There's lots of change around generally. Our vision for a modern, open and competitive legal market to support the UK economy has never been more important, particularly in the light of the Brexit vote. It's because of this that I firmly believe that rather than slow down because of Brexit, we should essentially speed up our reform process to make sure that we have a vibrant legal services market, a market that's open for business, and a solicitor's profession is fit for purpose to face the challenges that lie ahead in the months and years that follow. So the times, they are a-changing, to quote a recent Nobel Prize winner. And it's in this context I'd just like to touch on for a few minutes what we've been up to over the last year. Firstly, we're pressing ahead with a sharp focus on high professional standards. I see these as core standards, the issues of integrity, independence, confidentiality, etc., etc. They roll off the tongue. They're fundamental to public protection, they're fundamental to public trust, and they're fundamental to public confidence in solicitors. And of course, they are very much about what the solicitor brand is. Get those right and we can prune a labyrinth of rules, the rules that hold back the legal market, and that is our intention. It's about professional standards, it's about professional values, and it's about professional behaviours. It's not about rules, it's not about compliance. It's about who you are, who you should be, and what business and what the public can expect of you as a professional solicitor. Attendees at last year's conference will remember our Question of Trust campaign, and has already alluded to it. We looked at what should happen when things go seriously wrong, for example, the solicitor stealing money, that type of thing. Thousands of you voted on scenarios and dilemmas based on real cases. There was a huge interest, which is understandable because standards and ethics, after all, is very much what it's all about. The good news is that the public and the profession agreed on just about everything. The public understood the issues and talked from the heart about how they felt when the profession let them down, and the profession reaffirmed its absolute commitment to maintaining high professional standards. We're using the results of the review in a variety of different ways. We've already published a number of pieces of guidance on our website if you want to go and have a look there in relation to how we will use the outputs of that exercise. The exercise helps us to support our staff making consistent decisions based on a shared understanding of what matters to us all. And we've made some very significant internal improvements to the SRA in the last few years, but this is a work programme that will go on for some time, and it will certainly occupy our minds again in the months and the year ahead. And we'll be using the Question of Trust results as we undertake our enforcement strategy, the strategy which sets out how we deal with disciplinary issues with the profession. And we'll publish this strategy and make sure that it's a blueprint for how we do our disciplinary work moving forward. But where do these key standards come from? Most professionals, most solicitors will talk about education and training, they talk about shared values, they talk about professional conscience. Essentially, doing the right thing when no one is actually looking. That's vital for public protection, it's vital for public confidence, it's vital for public trust in the profession. And so, of course, is professional competence. Professional competence and the skills and knowledge that you need to practice as a solicitor. The gateway to the profession is absolutely critical. It's critical for maintaining high professional standards, and no one wants to see a professional, be they a dentist, a doctor, or a solicitor, who's not qualified to perform the role we all expect of them. So we have to keep entry to the profession under review to make sure the bar is set high enough and that the public and employers can be confident of who solicitors are when they enter the profession. The profession has changed radically. Back in the day, there were, some 40 or 50,000 solicitors. I've already alluded to the fact there's 170,000 solicitors in England and Wales, 136,000 of them are actually practicing law. So it's really, really important that we are vigilant in making sure that the right type of people enter the profession and that they can deliver the high professional standards that are required. So as you know, we've already launched our second consultation on a solicitor's qualifying examination. This follows on from our first consultation in the spring of this year. Our next session is very much on that piece of work. And as Ed said, we're very much in listening mode. It's about hearing what you have to say about the proposals that we've put forward. We've improved very much, I think, how we consult. And our first consultation on the issue, I think, perhaps rather boldly, was a huge success. We had lots and lots of input. We had lots and lots of questions and lots of challenges about the proposals that we're putting forward. But I won't steal Julie's thunder. Julie will be leading the session, which is coming up next, to talk about that. So I'll leave that there for now. I mentioned reducing bureaucracy, and we've recently also consulted on reducing our core piece of bureaucracy, which is the Solicitor's Handbook. But much of this is about something fundamental. It's not just about cutting the word count. This is about clarity. Clarity for each of you as individuals and clarity for firms. It's proposing a code of conduct for individuals and a code of conduct for solicitors' firms. And it's about freeing up solicitors, freeing them up to provide affordable services in new ways, removing unnecessary restraints to allow growth, competition and innovation, and importantly, access to trained and regulated solicitors for members of the public who presently can't afford the services of a solicitor. Over the summer, we consulted for 4 months on this issue and on our accounts rules, and perhaps the most controversial issue was the idea of allowing solicitors to practice outside of an authorised firm. The number one problem in the legal market is the vast majority of people cannot afford the services of a solicitor or a barrister. This is not a problem of our making, but it's certainly a problem that we need to deal with as a regulator. And over the last few years, we've done much to open up the market for legal services. We introduced over 400 ABSs, we changed our MDP rules, we changed the separate business rule to allow solicitors to compete. And now we're moving on to think very carefully about the idea of solicitors working in legal businesses without the overheads that unauthorised firms bring. 9 out of 10 members of the public do not go to see a regulated lawyer when they have a legal problem. 9 out of 10 small businesses say that the services of a solicitor are not value for money. The scale of unmet need is huge, but so is the market, and we all know that the present collection of reserved activities is more a historical accident more than anything else. So it must be right, surely, that the public or small businesses, when they need legal advice, their first port of call has to be a trained solicitor. It can't be right that properly trained or regulated solicitors are the only people who can't provide legal advice outside of an authorised firm. And it must be right to allow many, many more opportunities for solicitors, particularly young solicitors, to practice in different, new and innovative ways outside of traditional authorised law firms if necessary. And of course, the protections that they would have, or the public would have if they would do so, are not the same, and that's a major issue in relation to themes coming through from the consultation. They're not the same, and solicitors would want, and I believe would need to be really clear about the protections which would be afforded in such circumstances. But there's absolutely no evidence that people go to law firms because of the redress that's available. And there is a lot of evidence that if legal privilege did not attach to the advice that was given by such an individual acting outside of an authorised firm, that in the vast, vast majority of cases, such privilege is actually never required. So the consultation's finished. It will take us a few months to go through the significant amount of responses that we've received. The SRA board, under the chairmanship of Enid, will look at that probably in February or March next year. But it's an important development, and I've laboured it a little bit this morning because of that, and we'll be taking it forward carefully as we move forward with looking to the future programme. So lastly from me, before I round up, I need to mention information. How do people find out services that they need in the legal services market? How can we provide information that helps people make good choices? We know there's a real information deficit. Unlike other professional sectors, it's not easy to find information about law firms. Earlier in the year, we launched Law Firm Search, which is a basic tool online which allows people to check that the firm is authorised by us and to check basic contact information. We share the information with others, most notably the Law Society, but also with data republishers who produce comparison websites, that sort of thing. Disciplinary decisions and restrictions are also published, but let's face it, it's not very easy to find. So we want to do more. Asking the public what they want is probably the best place to start, so we did. And what did they say? They said that 9 out of 10 people wanted to know about the services, fees, charges and qualifications of solicitors, and they also wanted to know their disciplinary history. That echoes findings elsewhere, and some of that is very contentious, and very difficult indeed, particularly within the restrictions afforded by the Data Protection Act and getting it right. So today we're launching a discussion paper. It's not a consultation paper, it's a discussion paper looking at some of these issues. It's a rather controversial area, but we think it's a really important area for the people that buy the services of lawyers and, importantly here today, of solicitors. At the event last year, I talked about finding our identity as an organisation, as a regulator, and whilst improving our relationship with the profession and the way the organisation works, we've made some progress in that agenda. I think there's a little bit more to do. But today, I think, is a good start. And I'd like to take the opportunity to meet as much of you over the day as I possibly can. And I'd like to encourage you to take the opportunity to come up and speak to Enid and myself and the other board members that are here and tell us exactly what you think of what we're doing and how we can move forward. Just before I stop, there's a plenary session this afternoon, and it's a really, really important plenary session. Crispin Passmore, our policy director, will be leading it. And it's about professional indemnity insurance. Now, I can think of no other thing that causes is more troublesome in my time here than PII. And about 2.5 years ago, when we proposed a reduction in minimum cover, the Legal Services Board refused to endorse the change because it said that we don't have the evidence to move from the £3 million cover down to 500,000 at the time. Well, I can tell you we've spent a lot of time, Crispin and his team have spent a lot of time getting that evidence. And we have 10 years worth of claims covering 90% of the PII market to analyse. And what Crispin is going to do is to try to take you through some of that and look at what that data might actually mean as we move forward next year with a thorough review of the minimum terms and conditions in the handbook. So I just wanted to leave you with that because I think it's a really important session, and I've been to conferences like this, and it's always quite enticing just to slope off at lunchtime. But that's a really, really important session, and I'm sure you would value what we have to say then. So from me, welcome to our fourth compliance conference. Thank you very much for listening. I hope you enjoy the rest of your day. Thank you.